Good afternoon, everybody. I'm your host, the Supreme Litigant. I'd like to welcome everybody back to Smart Look TV. I know I've been gone for a while, but I've just been busy, y'all. If you're new to my channel, please go ahead, if you haven't already, pound that like button and that subscribe button. I'll give y'all a second to do that. Okay, so let's jump right into it. Um, if y'all ever watched any of my videos that talk about the merger of all of these courts into one court, I'm going to be elaborating on that a little bit, just a little, not too much, but just a little. So today I'm just going to be explaining to you what a court of equity is, and then I'm going to be explaining to you what equity is and what an equitable remedy is. A court of equity is a type of court with the power to grant remedies other than monetary damages. These remedies include injunctions, writs, or specific performance, among others. Traditionally, English courts followed a distinction between courts of law, which is common law, which could grant exclusively monetary damages, and courts of equity, which could not. The Court of Chancery was an example of an early English court of equity. In other words, what that means is a court of chancery is a court of equity. In courts of equity, the so-called judges are not called. They're not called judges. They're called chancellors. That's what they're called. So when you file a bill in equity, which is a complaint, it's not the pleading in equity is called a bill in equity. That's what it's called. The initial pleading that invokes the court's jurisdiction, and all that stuff. It's called a bill of bill of equity, bill in equity. I'm sorry. Anyway, um, the distinction between the two types of courts has now largely been dissolved. This is because they've merged all of these courts into one court, y'all. In the United States, the adoption of the Federal Rules of Civil Procedure in 1938 gave courts a combined jurisdiction over matters of law and equity. What happened? What was that case in 1938? Erie Railroad versus Thompson. 1938. I think that's what they're referencing in there without saying it. Bankruptcy courts and certain other state courts, such as Delaware, Mississippi, New Jersey, and Tennessee, can be considered as remaining examples of courts of equity. So if you're in any of these so-called states, let me know. Just comment on the video and let me know if courts of law, or an example, or at least the court of equity is separate from the court of law. Let me know that. Just comment it below. Let's go here. And I'm going to read y'all some examples of an equitable remedy. Specific performance, injunction, and restitution. A cause of action in equity is unjust enrichment. That's a cause of action in equity. Let me see. I'll read y'all. I'm not going to read all of this stuff. I'm going to read you some of it. A common type of equitable remedy used in the case of unique goods is called specific performance. In this type, a court orders the breaching party to fulfill the exact terms of the contract. For example, you run an art gallery. It's contracted to display a piece by a well-known artist in an upcoming exhibition. However, the dealer doesn't deliver the piece. The court can then order the dealer to produce that exact piece, so on and so forth. So let's go down. Specific performance. There's an injunction. So I'm gonna talk about this, not too much, but just a little. I believe that a court of equity is where you can get your remedy against the state for enforcing public policy on you without your permission or without some sort of minimum contact or something like that. An injunction is you're trying to stop them from basically violating your rights without a lawful purpose, or so to speak. It's something to that effect. I'm gonna read it to you though, just a little. I'm not gonna read too much of it. I'm just giving y'all a basic general understanding of it, and then I'm going to explain to you the purpose of a court of equity. Um, an injunction is another equitable remedy which directs someone to stop doing something which he or she should do. There's something interesting I want to point out on here. I'm gonna stop. I'm gonna read all the way down to about right here, and then I'm gonna stop, and I'm gonna read y'all some cases. So, uh, this is Wikipedia. Y'all already know that. Anyway, a court of equity, also known as equity court or chancery court, is a court authorized to apply principles of equity rather than principles of law. See what I'm saying? These courts were separate courts. So you could not go to a court of law to petition for an injunction. You had to go to a court of equity to do that. And if you're going to litigate a case in a court of equity, you would need to follow the equitable rules of procedure. All of these courts had their own rules of procedure for litigating cases in each of these courts. All of them had them. They had their own rules, but they've merged all of these courts into one court, and they have condensed all of these rules together. That is what they did. So you don't know if the judge is acting in an administrative capacity. You don't know if the judge is not a judge but a chancellor, and so on and so forth. You see what I'm saying? They did this to confuse people. That's why I think they did it, because there's no need for all of that. But anyway, let's see. Is a court authorized to apply principles of equity rather than principles of law to cases brought before it? These courts originated from petitions to the Lord Chancellor of England and primarily heard claims for relief other than damages, such as specific performance and extraordinary writs. Over time, most equity courts merged with courts of law. Are y'all paying attention? Told y'all they've merged all of these courts into one court. That's what they did, y'all. Pay attention. And the adoption of various acts granted courts combined jurisdiction. These are not courts, by the way. If these so-called courts were created by the legislature and they are following statutory procedure and they are enforcing statutes, that is an administrative agency. So what they have did was they have invested administrative agencies with quasi common law, equity, let me rephrase that, with quasi common law and equity jurisdiction via statutes. So it's not really a court. Well, it's not a court at all. It's an administrative agency, but it's not a court of law. It's a colorable court of law and a colorable court of equity, because there are no statutes in equity and there are no statutes in common law. Let's see. Where did I stop at? I'm gonna start back right here. Over time, most equity courts merged with courts of law, and the adoption of various acts granted courts combined jurisdiction to administer common law and equity concurrently. Courts of equity are now recognized by complementing the common law by addressing its shortcomings and promoting justice. In the early years of the United States, some states followed the English tradition of maintaining separate courts of law and equity. Others combined both types of jurisdictions in their courts, as U.S. Congress did for federal courts. So all U.S. district courts are courts, let me rephrase that, are administrative agencies that have been invested by Congress with quasi uh, equity jurisdiction and common law jurisdiction, because they're doing it under a statute. They're following statutory procedures. Only administrative agencies do that. United States Bankruptcy Court serve as an example of a U.S. federal court that operates as a court of equity. A few common law jurisdictions, such as U.S. states of Delaware, Mississippi, New Jersey, South Carolina, and Tennessee, continue to preserve the distinctions between law and equity, as well as between courts of law and courts of equity. In New Jersey, this distinction is upheld between the civil and general equity divisions of the New Jersey Superior Court. Um, if you're interested in learning some more about this, I'm gonna be studying equity a lot more than I have. I'm gonna be testing some of this stuff out down at the local courthouse down here, and I'm gonna come back and let y'all, know the outcome of what happened. I'm gonna be learning how to draft a bill in equity. It's pretty much the same way though, y'all. It's the facts. Are you pleading facts that show this is an that the nature of this action is at law, or are you pleading facts to show that this is a bill in equity? You just have to. It's all about the facts, y'all. It's always about the facts. Let's see. I'm not gonna read any more of this. I'm gonna get straight to the cases, and I'm gonna read on those some more. So, what is a court of equity? I'm just gonna kind of give y'all a little history lesson based on this case right here. This is a case from 1915. If you can, you're probably not gonna find this case online. If you do, some of the words that would probably be misspelled in it or something like that. So, I would suggest that you go to a local law library, and you can find this case citation either right here. That's one, or it'll be right on here, right there. Let me go back up. So, what is a court of equity? Again, first off, all pleadings. Let me rephrase that. The initial pleading that invokes the court's jurisdiction in equity is called a bill in equity. That's what it's called. So, equity is the portion of remedial justice which was formerly administered in England by the High Court of Chancery. Remember what I told y'all, the court of equity, they used to, in England, they call them a court of chancery. But in some places, most places here, they would call court of equity. By virtue of its extraordinary jurisdiction as extended, limited, and modified by statute and adopted to conditions by judicial construction. First, there ain't no statutes in equity. I'm just telling y'all that right now. Ain't no statutes in equity. I haven't seen any case at all that that says the equity has statutes, and there's no statutes in equity. It has like equity has a its own common law principles. Like equity is it's just its principles were created in a common law form. Meaning it was created by the chancellors, so to speak. But that's another story. We'll get into that later. Anyway, after many struggles with the law judges, notable among let me see, what was that? Notable among which is that led on the one side by Lord Ellesmere and on the other by Sir Edward Coke. Let me scroll down a little bit more. I kind of feel like I'm trying to get into the point to where it just tells y'all the purpose of equity and the whole hold on. This is an old case. I'm gonna read. Let me go back down. I think I'm gonna start. I think this is a good citation right here. So I'm gonna read y'all this citation right here, and that'll be it for this up here. Then I'm gonna scroll down. Equity is not the chancellor's sense of moral right or his sense of what is just and equal. It is a complex system of established law. So let's go down. When they say chancellor, they're talking about he looks like a judge. He's not a judge. They call him chancellors, so to speak. But anyway, Black's Law Dictionary states that the term equity, in its broadest and most general signification, denotes the spirit and habit of fairness, justness, and right dealings which would regulate the intercourse of men with men. And they're not talking about sex. They're talking about they're just doing business. In this sense, its obligation is ethical rather than jural, and its decisions belongs to the sphere of morals. This is very similar to common law. It is grounded in the precepts of conscience, not in any sanction of positive law. It adds that in a restricted sense, the word denotes equal and impartial justice. Justice that is ascertained by natural reason or ethical insight, but independent of a formulated body of law. And there's the case citation that supports that contention. Equity does not necessarily mean full compensation to the plaintiffs. Equity is justice administered according to fairness as contrasted with the strictly formulated rules of common law. The term equity denotes the spirit and habit of fairness, justness, and right dealings, which would regulate the intercourse of men with men. Black's Law Dictionary, blah, blah, blah. Equity then, I'm reading too fast, sorry about that. Equity takes into consideration fairness of both the plaintiff and the defendant, since equitable determinations require the balancing of many factors and are committed to the trial court's discretion. Let's see. I'll go right here. Before specifically discussing the pleadings involved herein, it is well to consider when a case is one in chancery, or in other words, one in equity. The terms equity and chancery are commonly used in the United States in the same sense, as will appear from the books. This usage, no doubt, is due to the fact that jurisdiction exercised in equity by our courts is assimilated to the equity or extraordinary jurisdiction of the Court of Chancery in England. As a matter of fact, I want y'all to pay attention how they talk about all of this stuff came from England, y'all. All of it came from it. What they did was they just changed the names of some of this stuff. Like that's it. I know for a fact that that's what they did with the courts of admiralty. They just changed the names of a lot of this stuff. But all of this stuff is still pretty much the same. It may have been modified a little. Like, for example, here they don't call them courts of chancery. They call them equity courts or court of equity, something like that. But all of this stuff is the same, y'all. As a matter of fact, if you go to your local law library, like I've done, I went to my local law library and I picked up the oldest law book in there on the shelf. And this is like from the maybe 1700s or something like that. And there are cases in there. And in these cases, when you read them, because the system of law was not developed here during that time, the judges back then were citing cases from England in support of their conclusions on why they were ruling the way that they were ruling. So I just want to point that out for y'all. Let me see that this interchange of terms is existence in the jurisprudence of this state is attested by the following language from Wagner versus Armstrong. Appealable cases, therefore, must be such cases as are now recognized as equitable in their nature, and perhaps the better way to express it would be cases that were recognized as equitable actions before the adoption of the Code of Civil Procedure. For while our code established under one grand division all actions, whether of an equitable or legal nature, and called them civil actions, yet there was no attempt to change the nature of the remedy. A chancery case is one in which, according to the usages and practices in courts of chancery prior to and at the time of the adoption of the Code of Civil Procedure, remedies were awarded in accordance with the principles of equity and not in accordance with rules of law. The term equity and chancery are interchangeable and are constantly used as synonymous in all of our states as well as in England. Let's see. It is earnestly urged here by the appellate in support of the judgment of the court below that the pleading filed was a bill in chancery, in other words, a bill in equity. No authorities in point are cited in support of this contention. Chancery is defined by Black's Law Dictionary, 3rd edition, page 308, as a system of jurisprudence administered in courts of equity. The same author, page 216, defines a bill in equity as a formal written complaint. Notice they don't call it a complaint. It's a bill in equity. Now you can call it a complaint. It doesn't matter what you call it. It matters what type of remedy that you're seeking, and the facts that you have pled in support of that remedy that you're seeking. You can call it a common law, a common law suit for assault and battery, but if you're not pleading facts to show a common law assault and battery case, then they're not going to treat it as that. If you're pleading facts that show that this is that you're seeking an equitable remedy, Is this making sense for y'all? I want y'all to understand this. It doesn't matter what they call it. Just like I was telling y'all when I showed y'all that case that said, despite its name, a tax court is not a court. Doesn't matter what they call it. It's the substance of it that matters. What are you asking for? That's what matters. Anyway, let me see. The same author, page 216, defines a bill in equity as a formal written complaint in the nature of a petition addressed by a suitor in chancery to the chancellor or to a court of equity or a court having equitable jurisdiction, showing the names of the parties, stating the facts which make up the case and the complaint's allegations, averring that the acts disclosed are contrary to equity, and praying for process and for specific relief or for such relief as the circumstances demand. Among the authorities cited in support of such definition, blah, blah, blah. Here's the case. Okay, look, I'm going to stop right there. I'm not going to get into this anymore too much. But I'm serious, y'all. I believe that a court of equity here, they've merged all the courts into one court here. So you would have to go to a court of general jurisdiction. General jurisdiction, they hear all types of cases. So that would be a circuit court. So you would go to a circuit court. You wouldn't file any statutes at all. You would simply plead facts that show. Let me see. You would plead facts that show, or you would plead facts averring that the acts disclosed are contrary to equity. You see what I'm saying? They're telling you how to plead your case. But in order for you to plead your case properly, you need to know what is an equitable remedy, and you need to know when you have an equitable cause of action, so to speak, something like that. This stuff ain't hard, y'all. I promise y'all it's not hard. This was very interesting for me. Just to let y'all know, I just started studying about equity. I just started studying it, and I just found so many cases about it. I have a ton more cases. I'll get back into that later. But I think these cases pretty much give you a good idea of what a court of equity is. And I really believe, y'all, that you can get your remedy in a court of equity by filing a bill in equity in a court of general jurisdiction or a court of chancery, aka a court of equity, against the state. You can petition for an injunction against them. Just to let y'all, let me see. In a 42 section 1983 lawsuit, just in that lawsuit alone, you can get an injunction and you can get monetary damages out of the same thing. That's proof that they have merged these so-called courts into one court. Although that U.S. District Court is not a court, it's an administrative agency, but they have vested all U.S. District Courts, which are administrative agencies, with quasi common law jurisdiction and quasi equity jurisdiction. That's what I call it, because it's not. They're doing it under a statute. Ain't no statutes in common law and ain't no statutes in equity, unless it's done under another particular jurisdiction, such as admiralty. Because if once the legislature creates an administrative agency and they invest that administrative agency with equitable let me rephrase that, quasi equity jurisdiction, then they can modify it. They can modify the types of equity cases that agency can hear, and so on and so forth. But y'all have to understand what's really going on. I strongly advise y'all to start studying equity. What I'll do is I'm going to draft, not right now, but I'm going to draft a bill in equity. I'm going to study it some more first, and I'm going to draft a bill in equity, and I'm going to show y'all how it looks. But anyway, that'll be the end of this video. Hopefully this helped y'all. Again, if you haven't already, please go ahead and pound that like button and hit that subscribe button. If I talked about something in this video that kind of confused you, let me know. Okay, and then I'll find a way to make you understand it. Anyway, that'll be the end of this video, y'all. Everybody enjoy their day. The Supreme Litigant is out. Peace.